we discuss a very recent decision of the Court of Appeal for Ontario, which sheds great light on the issues the court considers when the Ontario Securities Commission makes application for the appointment of a court-appointed receiver over the assets of a company. In this case, Cacoeli Asset Management. The case shows exactly how an insolvency trustee court order can stop improper conduct and protect investors. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. I hope you can watch until the end of the video, and I hope you find the information helpful.
Welcome to The Explainer. Today, we're diving into the really critical role court orders play in the financial world. And we're going to do it by looking at a high-stakes corporate case that shows just how these legal tools protect regular people from financial disaster. So let's jump right in with the question, what actually happens when millions of dollars of investor money just seems to vanish? It's a scenario that really puts our whole financial system to the test. $13 million. That's the staggering amount that was at the heart of a recent court case involving a company called Cacoeli Asset Management and 53 investors. $13 million that was supposed to be safe, but, well, allegedly it wasn't where it was supposed to be. So what exactly went wrong here? Well, the whole issue really boiled down to how investor money was being handled. In this case, it's a perfect window into why our regulators sometimes have to step in, and step in fast. Okay, here's the breakdown. Cacoeli raised money from investors for specific properties. So, you think your money is going to build Project A, right? But what an investigation by the Ontario Securities Commission found was that money was allegedly being shuffled around between completely different projects. That is a massive problem, and it has a name, fund diversion. At the end of the day, that fundamental promise made to investors, it was broken. So when investor money is at risk like this, the court can be asked to step in. And that is exactly what happened here. The OSC went to the court, and this kicked off a huge legal battle for control of the company's assets. And this is where it gets really crucial. Cacoeli's side argued that, hey, you need a very high standard of proof, basically rock-solid evidence before you can take control. But the court disagreed. They said, look, when it comes to protecting the public, we only need a serious concern that rules might have been broken. This lets them act quickly to stop the bleeding, instead of waiting years for a full investigation to wrap up. And this quote from the Court of Appeal just says it all. Their top priority? Public protection. Full stop. The court order to bring someone in isn't the final punishment. Think of it more like a protective shield. It freezes everything in place to figure out what's going on and make sure no more harm is done. So the court decides to intervene, but who do they actually send in to manage the chaos? Who's the person that makes sure everything is handled fairly? Well, let's meet this key player. They appoint someone called a licensed insolvency trustee, or LIT for short. Now, an LIT isn't just a lawyer or an accountant. They're a federally licensed professional, and you should really think of them as a neutral referee. They're an officer of the court, and their one and only job is to be impartial and balance the rights of everyone involved. And let me tell you, becoming an LIT is no walk in the park. You can see the path here. We're talking about rigorous education, years of hands-on experience, and a series of incredibly tough exams, including a final oral board. This whole process ensures that LITs are truly qualified experts that you can absolutely trust to handle these complex situations. And they don't just operate in a vacuum. LITs have this amazing system of dual oversight. The courts watch over the big legal decisions, and a federal body, the Office of the Superintendent of Bankruptcy, handles the administrative supervision. It's like having two sets of eyes on everything, which gives everyone confidence that the system is fair and transparent. Now, you might be thinking, this trustee has all the power, right? Well, not quite. While they can handle the day-to-day stuff, for any major decision, they have to go back to the judge and get a court order. And what counts as a major decision? Oh, things like getting their fees approved, selling off a big asset, settling fights between creditors, or getting a whole corporate restructuring plan signed off on. This ensures every single significant step is totally above board, legal, and protects the rights of everybody involved. Okay, so the Cacoeli case is this huge, complex, multi-million-dollar situation. But the principles here, getting expert guidance and having legal protection, they apply to any financial challenge, no matter how big or small. So if you or maybe your company are feeling that pressure, feeling overwhelmed by debt, it's so important to know that there's a structured, fair process out there to help you find a solution. You don't have to just figure it out on your own. And firms like Ira Smith Trustee and Receiver Inc. are exactly the kind of experts who guide you through that process. They're based right in the Greater Toronto area, and they help with everything from personal debt solutions, like consumer proposals, to complex corporate restructuring. They're there to help you explore all your options. Navigating financial difficulty really requires an expert and trustworthy guide. So the most important takeaway here is, don't face it alone. If you're an entrepreneur or an individual in the Greater Toronto area, reaching out for professional advice from a firm like Ira Smith is the absolute best first step toward finding a solution and taking back control of your financial future.